Hi everyone, my name is Sam Choi. I'm an associate in Covington and Burling's technology regulatory practice. I advise companies on data protection law and technology regulations on the horizon, such as those relating to artificial intelligence, digital health, autonomous cars, and other innovative data-driven solutions. Today I'd like to give you an introduction into the EU's proposed AI Act and discuss some practical considerations for companies. I'd like to focus on the EU's proposed AI Act in this session because it represents one of the most advanced pieces of AI regulations available globally. On today's agenda, we'll be giving a short introduction to the EU's proposed AI Act, discuss some key considerations for companies, and also think about what companies can do now to prepare. The EU's proposed AI Act was published in April 2021, and it establishes rules on the development, placing on the market, and the use of AI systems across the EU. This act is likely to enter into force in late 2022 or 2023, and it will apply to AI systems 2 years later. The territorial scope of the AI Act is that it will cover AI systems placed on the market or put into service in the European Union. It will apply to users of AI systems that are located in the EU and the output of AI systems used in the EU. It's expected to have extraterritorial scope because the focus of the Act is on where the AI systems will be used rather than on where the providers are used. The AI Act proposes to adopt a risk-based approach to AI regulation, and so there are 3 different buckets for how AI systems are regulated. For high-risk AI, there is a pre-market conformity assessment requirement and a post-market monitoring obligation. Those obligations are imposed on the provider who makes available the high-risk AI systems under its name or trademark. And there's a limited set of obligations on third parties, such as users, distributors, and importers. Another set of obligations apply to certain non-high-risk AI systems. And those are AI systems that are intended to interact with natural persons, such as chatbots, emotion recognition systems, biometric categorization systems, and technology used to generate deep fakes. And on those types of non-high-risk AI systems, transparency obligations are imposed so that providers of those systems need to make it clear to users that the systems are driven by AI. Finally, the AI Act has a list of prohibited AI practices, and that's listed on the slide here. This includes AI systems that deploy subliminal techniques to distort a person's behavior to cause physical or psychological harm, AI systems that exploit vulnerable people, and AI systems used in social scoring systems deployed by public authorities, and real-time biometric identification systems, such as FRT, or facial recognition technology used by law enforcement. The enforcement provisions of the AI Act state that some infringements could lead up to administrative fines of 30 million euros or up to 6% of total worldwide annual turnover of the company for the preceding financial year, whichever is higher. So we're looking at fines that are potentially larger than those under the EU GDPR. The AI Act will establish a new European AI board, and AI regulatory sandboxes will also be established. This is the general framework of the EU's AI Act, but let's dive a little deeper into some of the key considerations for companies. One of the key issues that I find when I advise clients is that they struggle with the definition of AI that they find in the EU's proposed AI Act. The definition of AI in the Act has 2 parts. In the operative definition provision of the Act, it states that AI is software that is developed with one or more of the techniques and approaches listed in Annex 1, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, and influence the decisions they interact with. And those are the elements of the definition of AI in the Act. Then there's a separate annex, Annex 1, which lists some techniques and approaches that AI systems use, such as machine learning approaches, logic and knowledge-based approaches, and statistical approaches. One of the issues that I find my clients struggling with is that this definition of AI is quite broad and could cover lots of sophisticated types of software that's not traditionally considered AI. Lots of sophisticated software systems use statistical approaches or logic and knowledge-based approaches, and they will, for a human set of defined objective, generate outputs and influence the environments they interact with. One of the criticisms of this definition of AI that I'm seeing being raised in the industry is that it doesn't have the element of autonomy that is considered key in defining what is AI or not. We're seeing a lot of different industry bodies providing input into the new EU AI Act, and so this definition of AI may change. But one of the key takeaways for you is that the EU AI Act defines AI very broadly, and it will require you to look at the different types of services and products and software that you provide with a critical eye to check whether the boxes are ticked for it to fall within the definition of AI. As I mentioned in the general introduction to the EU AI Act, there are different sets of obligations that apply to different types of AI systems. And the core obligations rest on high-risk AI systems. The high-risk AI systems are subject to the most onerous requirements to carry out a pre-market conformity assessment, obtain a CE mark, and carry out post-monitoring obligations. And what defines high risk is another aspect of the Act that I'm seeing clients struggle with. The definition of high-risk AI systems is set out in one of the operative provisions, and it says, high-risk AI systems are those intended to be used as a safety component of a product or is itself a product covered by the Union harmonization legislation listed in Annex 2. It also says AI systems listed in Annex 3 are also considered high risk. The AI systems that fall under the Annex 2 list are products such as medical devices, airplanes, vehicles, lifts, machinery, toys, the types of devices and products that are already covered under safety legislation under the EU are likely to be listed in that Annex 2. So if you work in a sector where there is already EU product safety legislation, you should check this Annex 2 to check whether the AI systems used in your products fall under this annex. As for Annex 3, Annex 3 has quite a diverse list of different uses of AI systems in different contexts that the Commission considers to be high risk. Some of the examples of those are AI systems used for biometric identification and biometric categorization of natural persons, such as AI systems that can identify somebody based on their photo or categorizing people based on race. Those would be considered high risk. Another example is AI systems used to make major employment decisions, such as decisions about hiring or promotion or termination of employment. And this includes both employment in the traditional sense and self-employment and algorithms selecting workers to allocate work to them. Another example is AI systems intended to evaluate the creditworthiness of natural persons. Those types of AI systems, although they don't form part of any product that are currently regulated under EU product safety regulations, these types of AI systems listed in Annex 3 will be considered high risk. One of the things that I see my clients do in preparation for the EU AI Act is to look critically at their systems, both the types of products and services that they produce for their own customers and their internal processes, such as HR processes, to have a good understanding of what sorts of technologies the company uses or plans to use that might have an element of AI, and identify whether any of those use cases would fall under Annex 2 or Annex 3. It's not always a straightforward exercise, so we suggest doing this early on while the Act is still in the draft stage, so that if there are use cases where you think AI systems might be used in your company, but you think that they shouldn't qualify under the high-risk categorization, you can input that into the consultation processes that are currently open on the EU AI Act. For those high-risk AI systems, you need to carry out a pre-market conformity assessment, and that pre-market conformity assessment will ensure that the AI system in question meets the key substantive obligations that are set out in Articles 9 to 17 of the EU AI Act. The key themes in those substantive obligations are listed on this slide. But a few words on some of those is some companies that I've worked with say that they would struggle to meet, say, the logging capabilities requirement under Article 12 because their data system architectures are just not designed to log in real time all of the different decisions made by the AI system. So some companies are having to rethink how they would comply with this obligation if it became an obligation that comes into force. Another thing that has been discussed widely in the media and in today's sessions is AI transparency. What does it mean for AI decisions to be explainable, AI models to be described in a way that's meaningful to users and to individuals that are impacted by the AI decision? That's something that we've had a lot of academic debates about. And for every AI system and the context in which it is deployed, the appropriate level of transparency will be different. And so companies need to think carefully about how they would comply with a transparency obligation. Another issue is human oversight. The European approach to AI regulation places a very strong emphasis on ensuring that humans are in the loop and they understand the decision-making that's going on with the AI system and that they can intervene if the AI system acts in an unexpected way or in a harmful way. That's more easily said than done. So in a lot of AI systems, it is slotted into a process that has no element of human oversight. And so from the perspective of the company deploying an AI system, trying to figure out where in the process should there be human oversight and what sort of powers, what sort of overriding decision-making powers should that human have? What sort of training and expertise should that human have to override that decision? What are the policies and SOPs that should be in place to ensure that any human oversight is fair and make sure that the human exercises meaningful control over the decisions? Those are all questions that companies are trying to grapple with, even at this early stage, to future-proof their AI projects. And finally, another topic that has been very key in some of the discourse on AI ethics is about data quality, data accuracy, and making sure that data sets are not biased. We've all seen lots of different media articles about AI having an element of unfair bias that is reflected in the training data sets on which the algorithm is trained. The AI Act places an obligations on companies to ensure a high level of data accuracy and representativeness of data sets. And although it says that at a high level, what does that mean when it gets into the practical considerations. How do you assess a data set for accuracy or representativeness? What are the kind of margins of error that are permissible? How do you go about recording a data set as being accurate? Those are all issues, again, that companies are trying to grapple with. And again, for every industry and every AI system, what is appropriate in terms of the level of accuracy will be different. So, for example, an AI system used in a medical device or in an autonomous car will need to have a very high level of accuracy to ensure safety of the drivers and the passengers on board. Whereas an AI system that makes admissions decisions or employment-related recruitment decisions will need to have a strong level of representativeness of the population on which it will be deployed to ensure that unfair bias does not get factored in, so that the AI system is fair. So these are, again, all considerations that need to be assessed for the AI system in question. So what can companies do now to prepare? One starting point is to look at the documentation that you should put into place to ensure that you're prepared, that your organization is prepared for the EU AI Act. Across the industry, I'm seeing companies adopt internal and external AI principles and policies on top of those principles to say, this is how we plan to develop and deploy AI in the context of our services. This trend of developing and drafting AI principles has been something that I see quite a lot in the technology sector and also in the life sciences sector and in the financial services sector. So it's the highly regulated industries where we see these principles and policies developing. One of the practical challenges with this is that once you publish a set of principles, you need to abide by them. And it's all well and good to say our AI systems will be fair, but the practical policies and processes that you need to adopt to ensure that you adhere to that principle, that requires a lot of thought and discussion, not only amongst the legal or the compliance or the privacy teams, but in conjunction with the engineers that are developing the AI system to ensure that what you're putting on paper is practical and can be implemented. Companies are also carrying out AI impact assessments on some of the use cases that they're developing already that are likely to fall within the high-risk AI category. So AI systems used in medical devices or AI systems used in autonomous cars. Impact assessments on specific projects can be done on the themes of the substantive obligations of the EU AI Act to future-proof the project. And in terms of working with third parties that develop AI tools, such as modular AI technologies or platforms where AI can be developed, companies are taking a lot of care in drafting the contractual terms for those, for the procurement of those services. And finally, as companies look to AI as a way to grow their business, they're being very careful about the due diligence that they carry out on target companies that hold AI technology. And some of those questions relate to things like, what is the target company's approach to ensuring ethical AI? Or what is the target company's approach to ensuring data quality? On this final slide, I've put some key themes to consider when future-proofing AI systems. The EU AI Act is not yet final, and so we don't have very good clarity over what will actually be in the final version of the Act when it becomes enforced. We're also aware that there are similar developments on AI regulation developing in the US, in China, and other important markets around the world. But in all of these, we're seeing some key themes. First, look at the quality of the data source. Second, transparency and explainability. Number 3, ensuring there's a human in the loop. Number 4, making sure there's very strong record keeping. Number 5, being thoughtful about strategic partnerships. Number 6, having strong internal governance structures in place to ensure all of the above has been set. And then having an escalation process for issues if they become raised by users or consumers. And finally, ensuring data security and system resilience. So these are all of the themes to consider that companies can think about now to future-proof their AI systems in expectation for the EU's AI Act. Thank you very much for listening, and I'll take questions.